Let us consider the votes and proceedings of Monday, 8 April 2019. Page 847. Page 848. I have examined the votes and proceedings of Monday, 8 April 2019, and approval is here granted. Mr. Clerk, any message from the governor?
Right, Honorable Speaker, distinguished honorable members, there is no message from
Any
the
other
governor.
announcements?
Mr. Speaker, sir, we have a correspondence from the Office of the Attorney General and Commissioner for Justice, Lagos State Ministry of Justice, addressed to the Clerk, Lagos State House of Assembly, the Secretariat, Ikeja, and it is titled, Re-Proposal for High Court Fees Rules. It reads, the above subject refers, please, Lagos State Executive Council at its meeting considered proposal for review of fees chargeable by the Lagos State High Court and resolved to present the attached High Court fees rules to the State House of Assembly for approval in accordance with the provisions of the Regulations Approval Law Cap R4 Laws of Lagos State 2015. Presently, the fees chargeable in respect of all High Court proceedings and allied matters by the State High Court are as prescribed by the State House of Assembly and specified in the High Court of Lagos State Fees Law, Cap A6 Laws of Lagos State 2015. This was an exercise of power to make rules of courts related to the costs of proceedings in the High Court, either though vested in the House of Assembly pursuant to Section 89, subsection 1 of the High Court Law, Cap H3 Laws of Lagos State 2003. However, the amendment of the said Section 89, subsection 1 of the High Court Law 2003 by Section 1, subsection 2 of High Court Amendment Law 2012, now Section 87 of the High Court Law 2015, the power to make rules of court is now vested in the Chief Judge of the state. This was necessary to bring the High Court law into conformity with the provision of Section 274 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, which empowers the Chief Judge to make rules for regulating the practice and procedure of the High Court of the state. In exercise of power conferred by Section 87 of the High Court Law 2015, the Chief Judge has now proposed the attached High Court fees rules for the consideration of the State Executive Council. In line with the resolution of the State Executive Council, please find enclosed 60 copies of the High Court fees rules for the approval of the State House of Assembly. Thank you. Signed, Mr. M. Adeniji Kazim, Attorney General and Commissioner for Justice. That's all, sir.
Petitions. Matter for general public importance, no personal explanation. Reports. Honorable Abiru.
Thank you very much, Mr. Speaker. Fellow members, good afternoon. I wish to bring to the attention of the House that sometime last week, between the 30th of March and the 3rd of April, the Right Honorable Speaker led the Deputy Speaker, myself, and 10 honorable members, the clerk, and 3 members of staff to a study tour of the Smart City project of Dubai. The Smart City is actually a city, it is a city that is that employs ICT in the delivery of quality service to the citizenry, that is actually regarded as a smart city. During the tour, we had the opportunity to visit the Emirates Tower, which actually houses the president of, the vice president of Dubai, who is indeed the vice president of the UAE, who is indeed the premier of Dubai. We also visited the artificial plantation site, whereby we saw how ICT was used in raising plantation. Again, we also visited the Atlantis, and we attended the blockchain exhibition. In all, it was indeed an experience, and for us as a city, of course, different cities has its own peculiarities. Part of the take-home from this tour for us is that Lagos State is anticipating the advancement of a city to a smart city, that for this to happen, there are quite a number of things that we need to put into consideration. There is the issue of, part of the things are the issue of energy, security, education, and leadership. In all, there was so much to take away from this tour. And on behalf of all other members, we want to thank the leadership of the House for considering us for the tour. Thank you very much, sir.
Thank you, Honorable Abiru. I think what you should add to it is the plan of Lagos State to also create what we call smart city, and there's no way you can supervise or perform oversight function on what you don't have knowledge of. And that was what a form essence of going to see what smart city is all about in Dubai. Thank you very much. Our Majority Leader.
Right Honorable Speaker, may I crave indulgence to defer my report till tomorrow, Mr. Speaker, till next sitting day, Mr. Speaker. I crave indulgence. I have a technical itch. Thank you, Mr. Speaker.
What is the next on agenda, Majority? On other people?
Mr. Speaker, I just have a copy of the other paper now.
You have what?
I just got the copy of my own copy of the other paper now, Mr. Speaker. Slated for today is motion, and I think the motion should go before the major business of the day. Mr. Speaker, next on the other paper should be House of Assembly motion number 63, which prime mover is Honorable Buramo T. Koshofe 1, supported by other honorable members, including myself, Honorable Oshun Emo, Honorable Shokunle H, Honorable Mohammed F.J., Engineer David S.S. from Badagry, Honorable Tobun M.A., Honorable Makinde R.L., and Honorable Jimo O.W., the Deputy Majority Leader. Mr. Speaker, may I humbly invite the Prime Mover, Honorable Bramoti, to present his motion to the House, Mr. Speaker, subject to your approval. Thank you, Mr. Speaker.
Yeah, go ahead.
Thank you, Mr. Speaker. Mr. Speaker, distinguished colleagues, I rise before you this afternoon to move a motion on the need to expedite action on the passage of the Electricity Power Reform Act Amendment Bill 2018. This House is aware that the Electricity Power Reform Act Amendment Bill 2018, which seeks to prohibit and criminalize estimated billing by the electricity distribution companies, the DISCOs, has been passed by the House of Representatives and is awaiting the concurrence of the Senate of the Federal Republic of Nigeria. The House is further aware that the pending bill compels all electricity distribution companies to distribute prepaid meters to applicants within 30 days of application, in line with Section 68 to 72 of the amendment bill. It further provides that electricity consumers not given prepaid meters will not be liable to make payments and are immune from being disconnected without notice. The House is concerned that the quantum and instances of public outcry against the activities of the Eco Distribution Company, Eco Disco, and Ikeja Electricity Distribution Company, Ikeja Disco, on the removal and seizure of electricity distribution transformers at various communities across the state for failure of some, but not all, consumers in paying their bills without consideration for other law-abiding residents in the affected areas. The House notes that the conduct of Eco and Ikeja distribution companies, otherwise known as DISCOs, in respect of seizure and removal of electricity transformers from communities is unacceptable and an infringement of the rights of residents who are not defaulting in the payment of electricity bills issued by the companies. The House observes that the conduct of the DISCOs may lead to a breach of the existing peace between the non-defaulting residents and those who are actually owing within the communities. And the House is disturbed by the unwholesome practice that denies law-abiding citizens access to electricity, which unarguably remains the most singular important invention in the last 1,000 years. The House therefore resolves to call on the Senate of the Federal Republic of Nigeria to expedite action on the Electricity Power Reform Act, Amendment Bill 2018, for transmission to the President of the Federal Republic of Nigeria for his assent. To call on the Honorable Minister of Power, Works and Housing, as well as the Director General, National Electricity Regulation Commission, NERC, to direct the Eco Electricity Distribution Company, Eco Disco, and the Ikeja Electricity Distribution Company, Ikeja Disco, to desist from further removing, seizing, distraining, or in any other way denying their consumers of electricity services by taking away the electricity transformers under the guise of non-payment
of electricity bill by some consumers, except for genuine reasons and verifiable reasons of repairs, in which case such transformers are to be returned or replaced within 30 days of removal. And B, to direct the electricity distribution companies, the DISCOs, to, as a matter of urgency, ensure that the installation of prepaid meters at all service points and regular maintenance of same across the state. I so move, Mr. Speaker.
Honorable Olulade.
Thank you, Mr. Speaker. I rise to second the motion as moved.
All in favor say aye. Those against nay. Ayes have it. I think the motion is very straight. No? So don't take it demands. Since everybody has lights on, Honorable Yusuf, what do you?
Thank you, Mr. Speaker. I need to give kudos to the prime mover of this motion. Mr. Speaker, is daily occurrence in Lagos State now that violent fighting, disturbance is daily occurring between the officers of DISCO and the residents. Mr. Speaker, it's very, very abnormal. It's only, it is not only injustice, it's criminal injustice on the part of the DISCO by what they are doing in Lagos State today. In my area, in my constituency, Mr. Speaker, they will come and remove the transformer, as the prime mover said. They may not replace it for 6 months. And when they are bringing the estimated bill, they will not take into consideration of the period they've removed the transformer, and they will still be demanding for it. Not only that, Mr. Speaker, even the transformers procured by the community, installed by the community, immediately they install it as becoming the property of them. And this is the only country where I will say that the investor will ask the consumer to pay for the establishments of their business, yet they will be billing the consumer. It's highly unfortunate, Mr. Speaker, and I think something drastically has to be done for this. Thank you, Mr. Speaker.
Thank you, Mr. Speaker. My colleague, good afternoon. I want to really commend Honorable Raymond for the thoughtfulness and for the depth of analysis. Mr. Speaker, it cannot be better because we are all facing problem in Lagos State, and which could be traced to even the emergence of the so-called DISCO and transition subsector of the electricity sector. Mr. Speaker, the first thing I'm looking at the structure of your prayers, and I appreciate it. But more than that, Mr. Speaker, is the fact that what is generated cannot be transmitted because the transmission subsector of that line do not have the capacity. If you are generating about 4,000 megawatts, the transmission is supposed to have about 6,000 megawatts for the uptake. Then ditto distribution, but if you are generating about 4,000 megawatts and the transmission cannot take it, how will you expect the DISCO to take it? So how we, in addition to his prayer, call on the Minister of Power to go back and make critical analysis of these companies, because bulk of them came in not to provide service but to extort. They don't have the financial muscle to meet our requirements in terms of providing transformers and the likes. Then secondly, Mr. Speaker, lately something happened, maybe some of us saw it on the TV when I led or I went to pacify some set of my communities, a Radiolua community in Shomolu. For over 4 months, we've been in darkness. And the reason is that the S1 transformer had issues. They removed it and now brought additional, they brought another transformer of lesser capacity. They removed 500 and brought in 300. How would they service people? Again, they were requesting for money. Mr. Speaker, I had to part personal money, about 1.5 million, to resolve that. But even at that, yesterday they were to activate the transformer. They didn't, Mr. Speaker. So my prayers are, in addition to what he is asking for, that even the heading might be changed. Need to overhaul electricity service providers. We need to overhaul all of them. We need to look at them critically. We need to add make more financial requirements of them, because what they are doing is not providing service, but the service to people. Then the near monopoly gesture of the provider had made the life of our people unbearable, miserable, precarious, because they see us as not having option than to meet their obnoxious requirements. Mr. Speaker, can you imagine where a woman that has only one room with only a deep freezer is made to pay an average of 28,000 naira a month? They brought crazy bills. Then if you don't pay, they will disconnect you. And even those that are using metering units, they disconnect them. So those that are not owing are disconnected. So, Mr. Speaker, I appreciate the mover, and I think it's high time we do something about it. Thank you.
Honorable Jibo.
Mr. Speaker, in respect to the bills before the National Assembly, it's a constitutional provision that the both house, the lower house and the upper house, must jointly pass it into law before the president can ascend into it. So it's not out of place that the discourse are playing with the upper house. However, Mr. Speaker, it is not only to call on the attention of the ministers of power to look at it in any way, because he has also made a pronouncement that no prepaid meter, we should not tolerate estimated bills. That we should also encourage our constituents and our people to also sue for punitive damages. Because I don't see the justification in an area where some people will pay and some people will refuse to pay, and everybody will be punished for this. We are all customers to these people. So if I paid my money, I should be entitled to what I have paid for. And the bills, if we don't make it as a point of responsibility that the metering system should be distributed and should be enforced, all these crises will continue facing our people. And I think it's a good bill. We need to add more to it by, emphasizing more on the prepaid meter, that the distribution of the prepaid meter, and how our people can have access to the prepaid meter. So you can quantify whatever you this is the contribution I feel I should add to the. Once again, it's a good bill. It's a good motion that needs to be encouraged.
Honorable Mohammed.
Thank you, Mr. Speaker. I also want to join in commending the prime mover of this particular motion. This has become something, an order of the day, where we see that the distribution companies are walking into areas, picking up transformers in the name of upgrading them without returning them. Most times you find out that this act occurs in rural areas where there has been a lot of...
Can you please increase the following, please?
You find out that this occurrence happens a lot in most of the rural areas where they witness a lot of unfair billing and estimated billings, and where the effect of non-payment does happen within the communities. The discos happen to go there, remove the transformers in the name of an upgrade or lack of capacity, and take it to more higher payment tendency areas and don't return it there. This pronouncement has been made by the Minister of Power and Steel recently, where he has warned that where there is no metering within a particular area, no payments should be made. It's a fantastic motion that has been moved. We want to use this opportunity to urge all the persons involved that there's a speedy passage of the amendment, the Electoral Sector Amendment Act of 2018. Thank you, Mr. Speaker.
Honorable Majid Fatai.
Thank you, Mr. Speaker. I want to join my colleagues to commend the prime movers of this bill, when the issue is an issue that affects both the poor and the rich, because the criteria used in distribution of the prepaid meter is known to the Eco Distributions Company. Take, for instance, how number 5 will be having a prepaid meters, number 6, number 7, number 8 will be the 9 of having such, and they continue giving a crazy bill. A communities in my constituency that have been in the darkness for almost 6 months. The transformer is down. The only thing the Eco Distribution Company did is to ask the community to contribute money for the maintenance of such transformers, in which I believe that is the primary responsibility of them to maintain the transformer. On this note, I join myself in condemning the activities of the Eco Distribution companies in this act. Thank you, sir.
Thank you, Mr. Speaker. I also want to commend the Prime Mover quickly, but in addition to what my colleagues have said, I think we should also call on the, in addition to the recommendation, the resolve, we should also call the Consumer Protection Agency, LSHA of Lagos State, because this is basically what we're talking about. Somebody pays his own bill, and because of somebody else that has not paid the bill, you deny everybody of power. That's unfair. It's not done anywhere. So it's important that we also ask that agency to follow suit in pushing for the rights of the consumer. Thank you, Mr. Speaker.
Well, thank you very much. I think we should just stop here on this. It's like we all have similar experience over this matter. Well, I think the prayer should go a bit further than what we have here. We should also appeal to National Assembly to allow each state or local government that can afford to generate, to distribute, to do same. I think this will reduce the problems we are talking about. Concentrating electricity on the center, while there is no enough manpower, resources to execute it, will not solve our problem. I think National Assembly should also go a step further by addressing the issue in the Constitution that will permit all the states, if they can afford to do so, to generate and distribute power. I hope the Prime Mover will be able to accommodate this in his prayer. So if you are ready, you can move your list.
Thank you very much, Mr. Speaker. Mr. Speaker, this House therefore resolves to call on the National Assembly of the Federal Republic of Nigeria to activate necessary measures aimed at amending Part 2 of Schedule 2 of the Constitution of the Federal Republic of Nigeria, 1999, to allow state government and local government authorities and other capable authorities who are able to generate, transmit, and distribute electricity within their areas to do so. Second, the House calls on the Senate of the Federal Republic of Nigeria to, in the meantime, expedite action on concurrence of the Electricity Power Reform Amendment Bill, which is pending before it for onward transmission to the President for his assent. Mr. Speaker, the House further calls on the Minister of Power, Works and Housing, as well as the Director General, National Electricity Regulation Commission, to direct the Co-Distribution Company and the Ikeja Distribution Company to desist from further removing, seizing, restraining, or in any other way denying their consumers of electricity services by taking away their electricity transformers under the guise of non-payment of electricity bills by some consumers, except for genuine reasons and verifiable reasons of repairs, in which case such transformers are to be returned or replaced within 30 days of removal. And also for the Minister and the NERC to direct the electricity distribution companies in Lagos State to, as a matter of urgency, ensure that the installation of prepaid meters at all their service points and regular maintenance of same across the state. We further call on the Lagos State Consumer Protection Agency, LSHA, to activate its machineries towards ensuring that the lots of consumers of electricity in Lagos State are protected. I so move, Mr. Speaker.
Honorable Olulade.
Rise to second the motion as properly
All in
moved.
favor say aye. Those against nay. The ayes have it. Thank you, Mr. Clerk. Kindly direct the resolution to concerned authorities. Yeah, Majority Leader.
Your Right Honorable Speaker, next on the other paper, presentation of reports. Mr. Speaker, for today, we have 2 reports listed for presentation. First is the Public-Private Partnership Amendment Bill 2018, to be presented by Honorable Ogundimu Agegetu as the Chairman Committee on Finance. Second being House of Assembly Bill number 60, in respect of Lagos State House of Assembly Service Commission Amendment Bill 2018, presented by Honorable Mrs. Miranda M.L. Apapa II, Chairman Committee on Establishment, Training, and Petitions. Mr. Speaker, to accommodate these 2 reports, may I humbly move that this House dissolves Committee of the Whole. I so move, Mr. Speaker.
Honorable Shah.
I second the motion.
All in favor say aye. Those against nay. The ayes have it. Yeah.
Good afternoon, Mr. Speaker and my colleagues. Report of the Finance Committee of Finance on a bill for a law to repeal and reenact the Lagos State Public-Private Partnership Law 2011. Mr. Speaker and distinguished colleagues, the House on its plenary session on 19 November 2018 committed the above bill to the Committee on Finance for further scrutiny and reports its findings. I seek the indulgence of Right Honorable Speaker to move to page 2 under observation. The generality, the observations 5.0. The generality of the participants commended the House for its proactiveness and responsiveness to the need of the people. However, the following observations were made by the committee from the observation of the stakeholders at the hearing. The interpretation section of the principal law should be brought forward to section 1 as is the practice of the House of Assembly. 2, the need to increase the tenure of the office of members of the board is observed. 3, it was observed that there is need for principal law and proposed amendment to be more detailed and encompassing to properly capture and adequately provide for the intendment of the law and proposed amendment. Hence, the need to create additional sessions, and those recommended sessions will be introduced in the recommendation, and some sections will be redrafted to properly capture the essence of the bill, as well as will be suggested in the recommendation below. 4, it was also observed that because of the volume of the amendment in the bill and the principal law, there is need for a repeal clause to be created, and it is either to repeal the principal law and reenact in order to accommodate the provisions suggested. 5, that there is need for provision of project management and monitoring team to oversee and certify all public-private partnership PPP projects to be included in the bill. 6, the provision for punishment of erring officers of the office and defaulting concessionaires are needed in order to deter circumvention of provision of the law. 7, it is noted that the MDAs, in trying to circumvent the public-private partnership law, enter into joint venture projects which contradict the principle and objective of the procurement and public-private partnership laws. Recommendation 6.0. From the above observations, the committee recommends that in view of the volume of the amendment and the need to harmonization, for harmonization, there is need for the principal law and proposed amendment to be repealed and reenacted as follows. 1. Move section 35 with the side note interpretations to section 1. 2. Old section 3 with the side note tenure of office, now new section 6. 3. The old section 4 with the side note section of office, now section 7. 4. Create a new section 4 with the side note responsibilities of the office, to read responsibility of the office. The office shall have the primary responsibility for the management and implementation of the public-private partnership project in the following phases. A, identification of phase. B, procurement phase. C, contract finalization phase. And D, implementation phase. 5, create a new section 5 with the side note establishment and composition of public-private partnership office governing board of the office, to read as follows. Establishment and composition of the public-private partnership governing board. 5.1. There is establishment of the public-private partnership office governing board, referred to in this law as board. 2. The board shall consist of a chairman who shall be of impersonable character with a minimum of 15 years cognate experience in the chosen field of specialization and registered with relevant professional body or bodies. B, 4 other members with requisite knowledge in finance, banking, engineering, or law with at least 10 years cognate experience registered with relevant professional body. And C, the general manager of the office. 3, all appointment of the board shall be made by the governor subject to the confirmation of the House. 6, O section 8 with side notes. Objective of the office is now section 3. 7, create a new section 9 with side note power of the board, to read the power, that is, the board shall have the power to that's the board. A, to oversee the implementation of policies formulated under the provision of this law. B, require any information from any party to a project on any matter relating to a public-private partnership. C, take custody of a project agreement made under this law and monitor compliance with the terms and conditions of the agreement. D, be the policy-making body on the public-private partnership for the state government. E, identify priority sectors for public-private partnership initiatives. F, take decisions on all issues pertaining to public-private partnership in the state. G, supervise the activities of the office and liaise with the governor on all issues pertaining to policy formation, evaluation of operational guidelines and other required statutory provision of the office. H, determine the framework of engagement of consultants, specialists, and or advisors for public partnership projects. I, plan and recommend budget for the office. J, create department for the office as it deems necessary. K, ensure that each project agreement is consistent with the provision of this law and any other relevant law. L, formulate policy guidelines on public-private partnership. M, formulate or approve standards, guidelines, and procedure for awarding contract and standardized bid documents. N, examine and approve the feasibility studies conducted by the office under this law. O, ensure physical accountability in the management of financial and any other form of support granted by the government in the implementation of the project under this law. P, ensure efficient implementation of any project management entered into by the office. And Q, perform any other function as may be conferred on it by this law or any other law. Now, Roman figure 8, create a new section 10 with the side note, meetings of the board to read thus. 1, the board shall meet at least once in a month. An extraordinary meeting may be convened in the case of exigencies. 2, the chairman shall preside at any meeting of the board, but in the absence of the chairman, the members present shall appoint one of the members to preside at the meeting. 9, create a new section 11 with side note, function of the office to read. That section, function of the office 11, that is, the function of the office shall be to A, initiate procurement of public-private partnership for the development of the public infrastructure and public access by conducting pre-qualification process for the private investors willing to enter into public-private partnership with the state based on requests for expression of interest. B, evaluate technical and financial proposal submissions or tender by private investors interested in public-private partnership with the state and issue a preferred mandate in accordance with the provision of this law and Lagos State Public Procurement Law. C, act on behalf of the government or any of its agencies in public-private partnership under this law and develop optimal means of financing cost of public investment projects in order to achieve value for money. D, ensure on behalf of the government or any of its agencies that all aspects of financing, refinancing, and insurance of public infrastructure and public assets are duly undertaken by means of public-private partnership within the public sector. E, prepare and develop on behalf of the state strategy master plan for public-private partnership. F, identify priority sectors for public-private partnership initiative. G, ensure that the interests of the state government and the contracting ministry, department, or agency is protected in all public-private partnership projects entered into by the state or a contracting ministry, department, or agency. H, initiate the development of public infrastructure and public asset through public-private partnership in the state. Determine the framework of engagement of consultants, specialists, advisors for the public partnership in the state. J, verify and monitor performance of the terms and conditions of concession agreement by concessionaires. K, advise the governor on matter relating to financing, construction, and maintenance of public infrastructure and public asset by means of public-private partnership in the state. and in particular identify and make recommendation to the governor with respect to the acquisition of land required for such purposes. I undertake or conduct any research, investigation, or inquiry and collect information relating to public infrastructure and public assets in general. Liaise with bodies of professional persons and private agencies performing work with regard to public infrastructure or public assets. And in relation to the public-private partnership initiative by the office, it shall, 1, ensure the provision by concessionaire of such facilities and amenities that are necessary for the users of public infrastructure or public assets. 2, oversee the development, operation, and maintenance of public infrastructure or public asset provided by means of public-private partnership and such other facilities necessary or adjacent to such public infrastructure or public assets. And 3, lastly, satisfy and discharge and perform the obligation of office and the state in order to uphold and observe the terms of any concession agreement subject to provision of this law. 10, create a new section 12 with the side note, quorum to read. Quorum 12. The quorum of the board shall be 4 members. 11, create a new section 13 with the side note, voting to read. Voting 13.1. Every question for decision by the board at any meeting shall be decided by a majority of the vote of the member present and voting. 2, the chairman or the member of the or member presiding in the chairman's absence shall at any meeting have a deliberative vote, but in the case of any equality of votes shall have a second and casting vote. 12, create a new section 14 with the side note, validity of proceedings to read. Validity of proceeding. The validity of a proceeding of the board shall not be affected or invalidated by any defect in the appointment of a member or by reason that a person who is not entitled to do so took part in the proceeding. 13, create a new section 15 with the side note, power to co-opt and to read. Power to co-opt 15. The board may co-opt any person or persons who is not a member of the board to any meeting of the board, and such a person may take part in the deliberations of the board but shall not be entitled to vote at the meeting of the board or count towards quorum. 14, old section 10 with the side note, power of the office is now 16. 15, create a new section 17 with the side note, feasibility study by the office to read. Feasibility study by the office. 17.1. The office shall undertake feasibility study of the project it tends to implement under the public-private partnership for the purpose of determining the validity of undertaking the project under this law. 17.2. In undertaking a feasibility study under subsection 1 of above, the office shall consider A, the technical requirement of the project, B, the legal requirement to be met by the parties to the project, C, the social, economic, and environmental impact of the project, and D, the affordability value for money and public sector comparator for the project as prescribed in this law or the regulation made under this law. 3, the office shall, upon conducting a feasibility study, prepare a report in the prescribed form not later than 2 months after the study. 4, on completion of a feasibility study, the office shall submit a project proposal including the completed feasibility study to the House for evaluation and approval. 16, create a new section 18 with the side note memorandum of understanding to read. Memorandum of understanding 18, the office shall obtain the approval of the House before proceeding to enter into any memorandum of understanding of the procurement phase of any proposed public-private partnership project. 17, create a new section 19 with the side note disclosure interest to read. Disclosure interest 19, a member of the board of the office having a personal interest, whether precautionary or otherwise, directly or indirectly, in any matter be considered by the board, shall disclose the fact of such interest and the nature, and such disclosure shall be recorded in the minutes of the meeting of the board, and such members shall take no part in any deliberation or discussion of the board relating to such matter. 18, move old section 12 with the side note appointment of the Director General of the office to section 20. In the same section, delete Director General and replace with General Manager. Do same wherever the phrase Director General appears in the principal law. 19, old section 13 with side notes, Secretary to the board is now section 21 and is redrafted as follows. Secretary to the board, 21.1. There shall be appointed by the board a secretary with at least 10 years cognate experience. 21.2. The secretary shall A, arrange meeting of the board and prepare the agenda and minutes of such meetings. B, convey decision of the board to the members, and C, perform all other functions affecting the board as may be assigned to him by the chairman. 20, create a new section 22 with side note procurement principle to read. Procurement principle 25, the procurement principle the procedure relating to a public-private partnership project shall be as follows. A, the procurement procedure shall be fair, equitable, transparent, competitive, and cost-effective. B, notwithstanding any provision of any other law, the procurement procedure shall be in accordance with this law and regulations or rules made under it and the procurement law. 21, create a new section 23 with side notes, nature of PPP agreement to read. Nature of PPP agreement. 1, a public-private partnership agreement. PPP agreement is an agreement between the state government or any of its ministry, departments, or agencies, MDAs, and a concessionaire made in accordance with the provision of this law, in which the concessionaire A, agree to perform or undertake any infrastructural development or social sector service project. B, assume financial, technical, or operational risk in connection with the performance of public function or the use of public property. And C, receives consideration for performing public functions or utilizing public property by way of 1, a fee from any revenue fund or budgetary fund of the government. 2, users' levies collected by the concessionaire from the end users or customer for a service provided. Or 3, a combination of the consideration paid under the subparagraph 1 and 2. Now 2. A PPP agreement shall provide for such matters as the parties considered appropriate, but shall include A, the nature and scope of works to be performed and services to be provided by the concessionaire. B, the condition for provision of services and extent of inclusivity, if any, of the concessionaire's right under the PPP agreement. C, the assistance that the office or the contracting ministry, department, or agency, MDA, may provide to the concessionaire in obtaining licenses and permit to the extent necessary for the implementation of PPP projects. D, the returns of assets, if any, to the state authority at the termination or expiration of the PPP agreement in such manner as may be provided for in the PPP agreement. E, in the case of a PPP project for the infrastructure, procedures for review and approval of engineering designs, construction plans, and specification by the office or contracting MDA, and the procedure for testing and final inspection, approval, and acceptance of PPP projects. F, the right of the office and the state or of a regulatory agency to monitor the works to be performed and services to be provided by concessionaire, and the condition and extent to which the office or the regulatory agency may order variations in respect of the works and condition of service, or take such other reasonable action as may be found appropriate to ensure that the PPP project is properly operated and the services are provided in accordance with the applicable legal and contractual requirements. G, the extent of the concessionaire's obligation to provide the office with report and other information on its operations. H, mechanism to deal with the traditional cost and other consequences that might result from any order issued by the office, including any compensation to which the concessionaire might be entitled. I, any right of the office to review and approve major contracts to be entered into by the concessionaire. J, remedies available in the event of default of either party. K, the extent to which either of the parties may be exempted from liability for failure or delay to comply with any obligation under the agreement owing to circumstances beyond its reasonable control. L, the duration of the PPP agreement and the rights and obligations of the parties upon its expiration or termination. M, the formula for calculating compensation under this law. N, the governing law and the mechanism for settlement of dispute that may arise between the parties to the PPP agreement concession. O, the right and the obligation of the parties with respect to the confidential information. P, the relevant financial terms. Q, the sharing of risk between the parties to the concession agreement. R, the corporate social responsibility to the host community, and S, such other information as may be prescribed or necessary. 22, create a new section 24 with the side note, request for expression of interest and pre-bidding document to read, request for expression of interest and pre-selection document. 25.1. The office shall prepare a request for submission of expression of interest and the associated pre-selection bidding document after receiving approval under section 17. 2. The office shall submit the request for submission of expression of interest and the associated pre-selection bidding document prepared by it to the board for written authorization to advertise, invite, solicit, or call for bid for the purpose of engaging in pre-selection proceedings. 3. The request for submission of expression of interest shall be published in accordance with the regulation and rules issued under the public procurement law. This law or the regulation made under this law. 4. The request for the expression of interest shall include the following: A description of the proposed PPP project. B, an indication of the essential element of PPP project, such as the 1, services to be delivered by the proposed concessionaire, and 2, the financial arrangement envisaged by the office. C, a summary of the main required terms of the PPP agreement to be entered into. D, the manner and place for the submission of application for pre-selection and the deadline for the submission expressed at the specific date and time, following the sufficient time for bidders to prepare and submit their expression of interest. E, the manner and the place for solicitation of the pre-selection bidding document. F, an appropriate statement to the effect that the office reserves the right to request proposals upon the completion of the pre-selection proceedings only from a limited number of the bidders that best met the pre-selection criteria. 5, the pre-selection bidding document shall include the following: A, the pre-selection criteria in accordance with this law. B, whether the office intends to waive any limitation on the participation of consortia in accordance with the section 29. C, whether the office intends to request only limited number of pre-selected bidders to submit the proposal upon completion of the pre-selection proceedings, and if applicable, the manner in which the selection shall be carried out. And D, whether the office intends to require preferred bidder to establish an independent legal entity under any other law in accordance with section 66. 23, create a new section 25 with the side note evaluation of qualification to read: 1, the office shall evaluate qualification of each bidder that has submitted an expression of interest for pre-selection, applying only on the criteria that are set out in the pre-selection bidding document and this law, and the office shall open and then prepare a pre-selection report for the consideration of the board, as specified in section 27. 2, each pre-selected bidder shall be invited by the office to submit a proposal in accordance with this law after the approval of the office pre-selection report as specified in section 27. Now 24, create a new section 26 with the side note approval of pre-selection report by office. 1, after the evaluation of the pre-selection bid pursuant to section 26, the office shall submit its pre-selection reports to the board for the approval, demonstrating how the pre-selection criteria have been met. 2, the pre-selection report shall contain the following statement: A, that the bid explains the capacity of the private partner to effectively implement, manage, enforce, monitor, and report on the proposed PPP project. B, that a satisfactory due diligence analysis has been completed by the board in consultation with the contracting MDA and in relation to the capacity and qualification of the selected private partners to complete the proposed PPP project. And C, that the contracting MDA has developed and is implementing a public awareness strategy to educate the public on the objective, structure, and progress of the PPP project. 25, create a new section 27 with the side note request for proposals to read: request for proposal after proposal 27. 1, the office shall prepare a request for proposal proposals after the board has approved the pre-selection report. 2. A request for proposal shall include the following: A. General information as may be required by bidders in order to prepare and submit their proposals. B. Criteria for evaluating technical offers and the benchmark, if any, set by the Office for Identifying and Non-Responsive Proposals, the relative weight to be accorded to each evaluation criterion, and the manner in which the criteria and the benchmark are to be applied in the evaluation and rejection of proposals. C. The date by which the bidder's proposals must be submitted, expressed at a specific date and time, allowing sufficient time for bidders to prepare and submit their proposals in response to the final version of the request for the proposals. D. Set of standard documents emphasizing functional requirements and performance criteria of the PPP project, rather than input specification for the PPP project, and a draft of all proposed PPP arrangement for the proposed PPP project, and E. The requirement with respect to the issue of and the nature, form, amount, and other principal terms and condition of the required bid security. 3. A request for proposal shall be required for the submission of both a technical offer and a financial offer, which shall be 2 separate documents as follows. A. The emphasis of technical offer shall be on the overall design of the PPP project, as well as on the related quality and condition of delivery, including the office requirements regarding safety and security standard and environment protection. B. The emphasis of the financial offer shall be on the lowest average price for the service over the limited time of the PPP project, the lifetime of the PPP project. 4. The office shall not issue a request for proposal to any pre-selected bidder unless it receives approval from the board to issue such request for proposals. 5. In support of a request for the approval of the issuance of the request for proposal, the board shall provide the House with a full legal and financial analysis of each proposed PPP agreement to be attached to the final request for the proposals, including an analysis of an investment initiatives offered to a private partner by or on behalf of the contracting MDA. 26. Create a new section 28 with the side note Public Procurement Agency Law of Lagos State to read Public Procurement Law of Lagos State. 28. All procurement provisions of this law shall be in accordance with the Public Procurement Agency Law of Lagos State. 27. Create a new section 29 with the side note registration under the companies and allied matter to read. 1. No matter department or agency MDA of the state shall enter into public-private partnership agreement with a person or company unless such is registered under Company and Allied Matter Act or Limited Liability Partnership Law of Lagos State. 2. All PPP agreement by MDA of the government shall be initiated through the office. 28. Create a new section 30 with the side note duration and extension of PPP agreement to read the duration of a PPP. 1. The duration of a public-private partnership shall set out in the PPP agreement, and the office may not agree to extend the duration except as a result of the following circumstances. A. A delay in completion or interruption of operation due to circumstances beyond the reasonable control of either party. B, suspension of PPP project brought about by act of the office or other public authority. C, an increase in the cost arising from requirement of the contracting not originally foreseen in the PPP agreement, if the concessionaire will not be able to recover such costs without such an extension. And D, on agreement with the concessionaire for a reasons for national or public interest as justified in the record to be kept by the office. 2, in determining the duration of the public-private partnership, the office shall take into account the following factors. A, provision of any relevant law. B, lifespan of the technology to be employed. C, investment standards that are required to be maintained by each party to the project agreement throughout the duration of the partnership. D, economic and financial viability of the project and the economic lifespan of the facility to be provided. E, depreciation of the project assets during the life of the contract. And F, the period of time that may be required by the parties to the partnership to 1, meet and maintain throughout the duration of the partnership the service delivery standard and investment levels, and 2, recoup their investments. Now 24, move the old 15 with the side note appointment of staff of the office to section 31. Now 30 now. Section 17 with side note, no state ministry, department or agency guarantee is now section 32. Now 31, move all section 19 with the side note fund of the office to section 33 and redraft subsection 2 to read. Gift, loan, grant, or aid from any agency, institution, bilateral or multilateral organizations, or any government, provided that the terms of the gift, loans, grant, or aid are not contrary to the objective and functions of the office and will not compromise its management. Now 32. O section 20 with the side note bank account is now section 34. Now 33. O section 21 and 22 are now section 35 and 36 respectively. 34. O section 23, 24, and 25 are now section 37, 38, 39 respectively. 35. O section 26 with the side notes ratification of cessation of agreement is now section 40. Now 35. Create a new section 44 with side notes project preparation and appraisal to read. 1. The office shall constitute a project appraiser team for the purpose of overseeing the preparation phase of the project in accordance with the regulation made under this law. 2. The project appraiser team constituted under section 1 under subsection 1 shall consist of a representative of the office and such technical, financial, and legal expert of the office as the office shall determine. 3. The office shall include in the project appraiser the team a member of the office under section 16 and such other person as the office shall consider necessary for the performance of the functions of the project appraiser team. 37. Create a new section 45 with side note enforceability of PPP agreement enter into without due authorization. If office A enter into PPP agreement with concessionary without having received all required approval from the House in accordance with the provision of this law. B, enter into PPP agreement with a concessionaire in contravention of a duration given by the House under Section 44. The PPP agreement shall be null and void and unforeseeable as against the office or the contracting MDA. 38, move section 30 with the side note, payment of service charge on user's fee and toll to section 46. Now section 39. Create a new section 47 with create a new section 47 with the side note evaluation of technical bids as follows. 47.1. The office shall constitute a proposal evaluation team for the purpose of evaluating bids submitted to it by the bidders under this law. 2. A proposal evaluation team constituted under this section, subsection 1 shall consist of A, at least one representative of the office nominated by the permanent secretary in the relevant MDA. B, a representative from the relevant contracting MDA. C, a representative of the office. D, a representative of Attorney General and Commissioner for Justice. 3, the proposal evaluation team shall open and evaluate the technical bids submitted to the office pursuant to this law within the time and in accordance with the procedure specified in the tender document and rules made under Section 44, subsection 3. 4, the proposal evaluation team may constitute committee for the purpose of receiving bids and carrying out the technical and financial evaluation of the bids. Now we move to 40. Create a new section 48 with the side note, evaluation of financial bid, to read 48.1. The proposal evaluation team shall invite the bidders who made pre-qualified, The proposal evaluation team shall invite the bidders who have been pre-qualified on the basis of their technical bid under Section 49 to attend a meeting for the purpose of opening the bids on the financial offer. 2, the proposal evaluation team shall evaluate the tender on the financial bid and determine the bid that meets the requirements specified in the tender document. 3, in evaluating a bid under the subsection 1 of the proposal evaluation team shall take into account the economic advantage that will accrue to the state if the bid is accepted and the comparative balance for the financial and technical element of the bid set out in the tender document. 4, the proposal evaluation team shall evaluate bids in accordance with the regulation made pursuant to the provision of this law. 41, create a new section 49 with side note, preparation of evaluation reports to read. 49.1. The proposal evaluation team shall, upon evaluating the bids and before declaring the first ranked bidder, prepare an evaluation report specifying the evaluation criteria, the manner in which the first ranked bidder satisfied the requirements specified in the tenders document in comparison with the other bidders, and such other information as the office shall consider necessary. 2, the office shall submit the evaluation report prepared under subsection 1 to the board for approval. 42, create a new section 50 with the side note, no restriction on use of innovation, to read 50. The office shall not restrict the use by a bidder of innovation with regard to the means of financing, application of technology, or the management approach that a bidder may use to deliver the the procured facilities or services. 43, create a new section 51 with side note, not compliance by a bidder. To read, a proposal evaluation team shall reject a bidder's submission where the bidder does not comply with the condition and requirements specified in the tender document or the rules made under section 28. Four, create a new section 52 with the side note negotiation to read 1. The office 1A, enter into negotiations with the successful bidder. B, request the second rank bidder to extend the validity of his bid pending the completion of negotiation with successful bidder. Now, 2, the agency shall constitute a negotiating committee consist of one person nominated by the office from among its staff. B, one person nominated by the contracting MDA from among its staff. C, such person representing such state MDA or as the office may consider necessary. D, where applicable, the transaction advisors appointed by the office under this law. 3, the negotiating committee and the legal advisor shall enter into negotiation with the successful bidder on the technical and financial terms of the project agreement. 4, the negotiation carried out under subsection 3 of this section and the resolution of the parties to the negotiation shall not result in any increase in pricing and shall not affect the non-negotiable terms and conditions specified as non-negotiable condition in the invitation to tender, the financial structure, or the condition in respect of which there are no reservations raised by the bidder in the bid. 5, the parties to negotiation under this section shall not amend the negotiated terms and terms upon which the bid has been evaluated. 6, where the parties to the negotiation carried out with the successful bidders as unsuccessful, the negotiating committee shall enter into negotiation with the second rank bidder. The 7, the provision of subsection 3, 4, 5 shall apply to the negotiation with the second rank bidder. 8, the negotiating committee shall conduct the negotiations in accordance with the regulation made under this law. Now 44, create a new section 53 with the side note, preparation and submission of project and risk report. To read, the negotiating committee shall, upon conducting negotiation under section 54, prepare and submit to the board a project report specifying the negotiated terms together with its recommendation. 2, the board shall review the project report submitted to it under subsection 1 and shall, where it's satisfied with the recommendation of the negotiating committee, proceed with the provision of this law. 3, the general manager shall present the report of the agreed negotiated sum to the House for ratification in accordance with section 43. 4, where the office or the House is not satisfied with the recommendation of the negotiating committee, the office shall refer the the project report back to the negotiating committee with its reasons and request for review of the report. 5, the office shall review the project report submitted to it under this section, and such report shall be forwarded to the debt management office for confirmation of its initial approval at feasibility stage based on the final contract and preferred bidder submission. 46, move old section 34 with the side note pre-existing concession to 56. 47, move section 28 with the side note authorization to collect user's fee or toll to 57. 48, create a new section 58 with side note direction of the governor to read one, the governor may give directions to the agency in respect of the management of any phase of a PPP project after consultation with the general manager and commissioner responsible for the sector affected by the PPP project. 2, the office shall comply with any direction given by the governor referred to in subsection 1 above. 48, create a new section 60 with side note substitution of concessionaire to read substitution. The office may agree with any entity extending the financing for a PPP project and the concessionaire to provide for substitution of the concessionaire with another person appointed to perform under the existing PPP agreement upon a material default by the concessionaire or other event that could otherwise justify the termination of the PPP agreement. 50, create a new section 61 with the side note execution of a contract to read 61. The office shall, where the house approve the undertaking of a project as a public-private partner under this law, execute the contract awarded to the bidder. 51, create a new section 62 with the side note privately initiated investment proposal to read 62.1. The office may consider a privately initiated investment proposal for a project and procure the construction or development of a project or the performance of a service by negotiation without subjecting the proposal to a competitive procurement process where there is an urgent need for continuity in the construction, development, maintenance, or operation of a facility or provision of a service, and engaging in the competitive procurement process will be impractical, provided that the circumstances giving rise to the risk of disruption were not foreseeable or by the office or the result of an unforeseeable failure to act by the office. B, the cost relating to the intellectual property in relation to the proposed design of the project is substantial. Or C, there exists only one person or a firm capable of undertaking the project, maintaining the facility or providing the service, or such person or firm has exclusive right over the use of the intellectual property, trade secrets, or other exclusive right necessary for the construction, operation, or maintenance of facilities or provision of the service. 2, The office shall, before commencing negotiation with a concessionaire under this section, A, prescribe a criteria against which the outcome of the negotiation shall be evaluated. B, submit the proposal to the board for consideration and approval. C, conduct the negotiations and award of the tender in accordance with the prescribed process in the regulations to this law. 3, the office shall not consider a project for procurement under this section unless it is specified that the A, project shall provide a value for money. B, project shall be affordable. C, appropriate risk are transferred to the private party. 52. Create a new section 63 with side note project management. 63A. The MDA that is a party to a project agreement in conjunction with the office shall, together with sector regulators, where applicable, ensure that the project agreement is properly implemented by 1. A, monitoring the implementation of the project agreement. B, measuring the output of the project. C, page 24. Yes, sorry. So C, liaising with the private party and users of the facilities or services and other relevant stakeholders. D, overseeing the management of the project agreement. E, preparing periodic reports on the project agreement implementations. And F, submitting report on the project agreement implementation to the board in June and December in each year of the project. 2, the office shall appoint an independent expert to manage, in consultation with the contracting MDA, the implementation of the project agreement by the parties. 3, a project agreement involving the performance of a function of the office by a concessionaire shall not divest the office of the responsibility for ensuring that its function is effectively and efficiently performed in the public interest. 4, a project agreement involving the use of the office property by this private party shall not divest the office of the responsibility for ensuring that the property is appropriately protected against the factors which may be negatively affect the property, including the forfeiture and theft, loss, and wastage. 5, the relevant committee of the House shall, in the exercise of its oversight function, ensure the implementation of every project embarked upon by the office. 6, the sector regulatory bodies shall play an active role in the project implementation phase through the monitoring of the performance of the office and the private party in accordance with the procedure prescribed by the board under this law. 53, create a new section 64 with the side note joint venture project to read 64. As from the commencement of this law, all joint venture projects to be undertaken by any MDA shall be subject to the provision of this law. 54. Create a new section 65 with the side note project certification. 65(1). A team of duly authorized officers of the office shall inspect and certify a completed project in accordance with the contractual terms and conditions of the agreement. 2, any officer of the office who falsely certify a project to be completed or ready for delivery when it is not, commit an offense and is liable to a criminal proceedings under the criminal law as well as disciplinary actions under the civil service rules. 55. Create a new section 66 with side note, tampered report and illegal collection of gratification. 66(1). As from the commencement of this law, any officer or project management consultant charged with monitoring and reporting on a project who connives with a contractor to write a fake report or a report that cancels the inadequacy of a project inspected, commit an offense and is liable commit an offense and is liable in case of an officer to a 3 months imprisonment and appropriate disciplinary actions in the civil service rule, and in case of the project management consultant to a 3 months imprisonment and a fine of 500,000 or both, or to both fine and imprisonment. 2, an officer that demands for bribe or gratification in carrying out the duties and obligations of his office under this law commit an offense and is liable under the provision of section 68 of the criminal law. 56. Create a new section 67 with the no dispute resolution. 67(1). All concession agreements shall contain an arbitration clause for the resolution of dispute which may arise concerning the concession agreement. 2. Any dispute between the office and a concessionaire shall be settled through the dispute settlement mechanism agreed by the parties in the PPP agreement, or in the event of a failure of such mechanism in accordance with section 26 of Lagos State Arbitration Law, Cap A11 Law of Lagos State 2015. Now 57. Create a new section 71 with side note, repeals to read 71. The following laws are repealed. 1. The Lagos State Roads Private Sector Participation Authority Law number 7 of 2017 is repealed. 2. The Public-Private Partnership Law, Chapter P18, Volume 9, Law of Lagos State, 2015. 58. Move all Section 31 with the side note offenses and penalty to Section 69. Now 59. Create a new 72 with side note savings to read savings. Nothing in this law shall invalidate any action done or purported to have been done under the repeal law. 60. Create a new section 73 with side note citation and commencement to read citation, and so to read, this law shall be cited as the law of Lagos State Public-Private Partnership Law, and it shall come into effect on this day, 2019. Conclusion: the committee expresses gratitude to Mr. Speaker and members for the opportunity given to us to carry out this assignment, and we also appreciate Mr. Clerk and the House and Secretariat for the support at ensuring the timely completion of this report. Thank you all. Honorable Yinka Ogundimu, Chairman, Committee on Finance. Thank you.
Majority Leader.
Right Honorable Speaker, may I humbly move that this House proceeds on a very short break.
You can take that again, I can't hear you.
Sorry, Mr. Speaker.
You can take that again.
Mr. Speaker, I wish to move that in line with the rules of the House, that this House proceed on a very short break.
Honorable Olo,
Thank you, Mr. Speaker. I stand to support the motion as moved.
all in favor say aye. Those against no, the ayes have it. This House stand adjourned for recess of 5 minutes. I rise. Yeah, distinguished colleagues, you are welcome back from short recess. Majority Leader, can we have the second report? Or you have jointly moved the motion? Honorable Miranda.
Good afternoon, Mr. Speaker. Good afternoon, colleague. The report of the Committee on Establishments, Training, Pensions, and Public Service on a bill for a law to amend the Lagos State House of Assembly Service Commission Law, Cap L34, Volume 5, Laws of Lagos State 2015. With your kind permission, Mr. Speaker, I would like to go straight to the observations, sir. The following observations were made at the stakeholders meeting. 1, Section 4, Line 2. Delete the word is after of and insert there. Also insert the phrase and may be reappointed after appointment in the same line. Roman figure 2, still in Section 4, Line 3, change the word year to years. Roman figure 3, Section 6, Subsection 1, Line 2. Delete the word governor after Article D and insert speaker in consultation with the principal officers of the House. Roman figure 4, Section 8, Subsection 1, Line 1. Delete the phrase, there shall be for the commission before Article A and insert the speaker upon recommendation of 3 names by the commission shall appoint. Roman figure 5, Section 8, Subsection 4, Line 2. Insert the phrase by the speaker in conjunction with the commission after appointed. Also in the line 3, insert no more than 6 months after capacity. Roman figure 6, Section 20A1, Line 3, delete the words directors on grade level 17 before to and insert deputy clerks. Roman figure 7, Section 20A4, Line 3, delete the phrase and 21 of the principal law after Section 20. Roman figure 8, Section 21 of the principal law should be deleted as the appointment of the clerk should not be subjected to tenure of office, but rather in line with the retirement policy of the state's civil service. Roman figure 9, Section 22, Subsection 1, Line 1. Delete the word 8 and insert 5. Also delete subsections 1, Roman figure 6, 7, and 8, and repeat same wherever it appears, so as not to make mockery of the position of permanent secretary due to number of officers to be controlled and functions under those departments. Roman figure 10. The position of the clerk vis-a-vis the deputy clerk was not indicated in the proposed law. Roman figure 11. The law was silent on the nomination of deputy clerks, and this should be spelled out. And Roman figure 12. The functions of the secretary to the commission should also be spelled out. Recommendation 6.0. Based on the affirmation observations, the committee hereby recommends the following. 1. Section 2, subsection 1 and 3 is deleted and replaced with a new section 2, 1, and 3, with side notes, composition of commission as follows. 1. The commission shall comprise of a chairman and 4 other members, who shall, in the opinion of the Speaker, be a person of unquestionable integrity and shall represent each of the 5 divisions of the state. 3. The Speaker of the House shall, after consultation with the principal officers of the House, send proposed names of the chairman and other 4 qualified members of the commission to the governor for appointment. 2. Roman figure 2. Delete section 4 with side note tenure of office of the principal law and replace as follows. The chairman and members of the commission shall hold office for a period of 5 years from the date of appointment and may be reappointed for a further term of 5 years, only subjected to reconfirmation of the House. Roman figure 3. Delete section 6 subsection 1 of the principal law and replace with a new section 6.1 with side note filling of vacancy as follows. Upon the expiration of the tenure of members in the event of any vacancy, the Speaker, in consultation with the principal officers of the House, shall within 30 days fill the vacancy. Roman figure 4. Delete section 8 of the principal law and replace with a new section 8. Side note, Secretary of the Commission as follows. 1. There shall be for the commission a secretary who shall on appointment have the status, rights, and privileges of a permanent secretary. 2. The secretary shall be appointed by the Speaker from a list of 3 names recommended to the Speaker by the Commission of Officers in the Director Cadre on grade level 17 in the State Legislative Services. 5. Create a new section 9 with side note mode of appointment of the secretary as follows. One, the Speaker, after due consultation with the principal members of the House, shall appoint the secretary to the commission in accordance with this section. 2, the condition of service of the secretary to the commission shall be as impeccable to the permanent secretaries in the state civil service. 3, in the event of any vacancy in the position of a secretary, an acting secretary will be appointed by the Speaker in conjunction with the Commission to act in that capacity no more than 6 months, pending the appointment of a substantive secretary. 6, create a new section 10 with side note Sergeant at Arms Directorate as follows and renumber accordingly. 1, there is established the Sergeant at Arms Directorate. 2, the head of directorate shall be a retired major or its equivalent in other service with cognate experience. 3, the directorate shall be saddled with the following responsibilities. A, promote improved standard of security in the House. B, ensure secured and safe environment of the House. C, advise the House on matters relating to security. D, formulate and implement strategies to promote environment in the House. E, identify security needs, trends, and advise accordingly. F, coordinate the activities of the security in the House. And G, collaborate with other security agencies in relation to the security of the House in the state. Roman figure 7. Create a new section 20 side note as mode of appointment of clerk and renumber accordingly. Mode of appointment of clerk. 1, in appointing the clerk of the House, the Commission shall recommend 3 names of deputy clerk to the Speaker after due administrative process from the list submitted to it by the Commission. 2, the person so nominated shall be presented to the House for confirmation by simple majority of members. 3, the person so confirmed by the House shall then be appointed by the Commission in line with the provision of Section 21 of this law. Roman figure 8, delete Section 21 of the principal law with side note tenure of office as follows. Tenure of office. The clerk shall hold office for a period of 4 years from the date of appointment and may be eligible for reappointment for a further term of 4 years, only subject to the retirement policy of the state civil service. Roman figure 9, delete Section 22 and replace with side note deputy clerks as follows. Deputy clerks, 1, there shall be for the House 5 deputy clerks as listed below. 1, deputy clerk legislative matters. 2, deputy clerk legislative drafting and legal services. 3, deputy clerk publications. 4, deputy clerk administration and human resources. 5, deputy clerk finance and accounts. And 2, the deputy clerk shall A, be an officer on grade level 17 from their respective directorates. B, hold office on such terms and conditions as may be applicable in the Lagos State Legislative Service. 3, the deputy clerk shall generally perform duties as may be assigned to them by the clerk of the House. 4, the deputy clerk shall be of the same status and rank as a permanent secretary in the state civil service and shall enjoy all rights and privileges of a permanent secretary in the state civil service. Delete old Section 24, subsection 3B of the principal law and renumber accordingly. 11, delete old Section 25 of the principal law and replace with a new Section 25 as follows. 1, the Commission shall not later than 30th September in each year submit to the House the proposed estimate of the income and expenditure of the Commission for the following year. 2, the proposed estimate refers to in subsection 1 above will be forwarded to the Ministry of Economic Planning and Budget, together with the proposed estimate of income and expenditure of the House. Roman figure 12, delete old Section 27, subsection 1 of the principal law and renumber accordingly. Roman figure 13, delete Schedule 1.2b of the principal law. Roman figure 14, delete Schedule 2.1 to 2.8 and replace as follows. 2.2, Legislative Matters Directorate. 2.3, Legislative Drafting and Legal Service Directorate. 2.4, Publications Directorate. 2.5, Administration and Human Resources Directorate. 2.6, Finance and Account Directorate. 2.7, Public Affairs Directorate. 2.8, Budget Planning Research Directorate. 2.9, Works Directorate. And 3.0, Sergeant at Arms Directorate. Roman figure 15. The principal law is amended by adding the definition of director to old Section 31 as follows. Director means an officer on grade level 17 in the state civil service or its equivalent. Roman figure 16, Section 19, line 3, delete 2018 and replace with 2019. 7.0, conclusion. The committee expresses gratitude to Mr. Speaker, members, and the committee clerk for the opportunity given it to carry out the assignment in the same vein. Appreciation also goes to the clerk of the House at ensuring the timely completion of this assignment. Thank you, Honorable Mrs. Miranda Mujisola Lasba, Apapa 1, Chairman, Committee on Establishment, Training, Pensions, and Public Service. Thank you, sir.